Afternoon, everyone. Welcome to the August Strategic Update. This afternoon, Williza and I are going to be walking through some estate planning considerations for everyone. Just wanted to obviously introduce Williza because many of you, well, some of my clients will know Williza from a past life. But Williza joined the business, 12 months ago? Nearly 12 months ago. Yep. So, just wanted to introduce her to you, get everyone to know who she was, and obviously talk about something that might interest you. So, Williza, do you just want to introduce yourself to everyone and let everyone know what your journey's been and, what's your role and how you're helping?
Sure. Well, Chris and I knew each other probably about 10 years ago. We used to work with one another.
I think, is it 10 years?
And back then I was a junior power planner.
That's right.
Helping you write statements of advice.
Yes, the good old days.
Yeah, and then we went our separate ways and I continued on power planning.
And I've always been, I don't know whether I've always been harassing you, but in my mind I've been like, I need to get Williza back because she was so awesome.
And just, I guess, about a year ago, everything just lined up.
Fell into line, which was awesome.
Here we are, together again.
Yeah, no, it's great. So it's been awesome to have you on board. And I guess, as I said, some of you would know who she was from dealing with her in terms of clients within here. And some of my older clients will remember her from the Planwealth days. But obviously, Williza brings lots of experience, a really great capable skill set, which we're going to discuss today. So we just wanted to have a bit of a chat to everyone, about estate planning. It's something that we're paying a bit more attention to in the business recently. Obviously, a really important part of what we do, but I think it's just a good idea to walk through, what are some of the key considerations that, as clients you might want to think about, and what are some of the key conversations that we consistently have with clients as well. We'll put together a bit of a pack. So, Williza, after you. All right. So I just wanted to, talk about, what is estate planning, working out, what's the best way to structure your personal affairs. And so this is all, excuse me, what happens if one of you pass, and what happens if both of you pass, effectively from a monetary standpoint, where does the money end up, and what are the tax outcomes of that, and what are the financial outcomes of that for your beneficiaries? So, Williza, do you want to walk through, some of the finer points?
I guess it also covers if one of you were to lose capacity to make decisions.
Yeah, absolutely.
It definitely covers that as well.
Yep.
So it allows you to nominate someone to act on your behalf if you can no longer make decisions. You can decide if you want your super and insurance to be included in your estate.
Yep.
We'll talk about that a bit.
In more depth.
What falls under the estate and what doesn't.
That's a pretty important point, actually, because the what happens when you die part is probably the easiest, I think, aspect to maybe deal with, because you can kind of make a decision and say, I'm no longer here. It's just sort of easy. But that incapacity where I'm still here, but I just don't have the capacity to make decisions. Someone else needs to make financial decisions that not only look after themselves but look after me as well.
Mm-hmm.
That's a really
big one, because I guess you run the risk of someone you may not want at all making decisions on your behalf.
Yeah, yep, definitely. And look, it's also a hard one, because there are people out there who may not have, people who they would automatically think of in terms of close family or friends to fulfill that role, and there's not a really apparent person, which makes this conversation really difficult. I've actually had one of my more enjoyable clients actually pass recently, and they were in that position where there wasn't an immediate person within their vicinity that they would have, say for example, I don't know, a brother or a sister or something along those lines. And it was interesting having a conversation with this client 12 months ago and saying, well, it's really important, you know, you're getting to a later stage in life. You should really think about, you know, who's going to fulfill these roles for you. And then having the subsequent conversations with them where he was saying it's really difficult to choose because there was no one who was there, but ended up getting through that process, and it was really only, you know, maybe 3 or 4 months after that had all kind of been signed off that he unfortunately passed. So, but also such a positive now because, you know, it's going the way he wanted it to be allocated. So, yeah.
And I guess one of the biggest parts of estate planning is a will. And it's really important to have. It allows you to appoint an executor and a trustee and specify how you want your assets to be distributed.
Yeah, definitely.
And to whom.
I think, most people will kind of be fairly across, you know, the need for this. It's just find it, I don't know if in your experience you've found that there's a bit of resistance sometimes in terms of having to, because the decisions are hard to make. Who and how?
Yes, definitely. And especially if you've got small children, you're also able to nominate a guardian, which isn't binding, but the courts will take it into consideration.
Yeah, definitely. Yeah, that one's huge, right? And, you know, those with family members with disabilities too. That's where this aspect can be really challenging, because you've got to confront situations that people want to kind of avoid thinking about. So it's but in that sense also why it's so important.
Definitely.
So I think we just brought up a bit of a table here, just so I guess this is a bit of an education piece for people, just to sort of give you a bit of a rundown of maybe it's typical for those who are in your sphere of influence. This might be completely non-typical of your experience, but I think it's a good illustration of the different types of assets, and, you know, what would be the impact in the event of, you know, a passing or of both or one partner. So I've got Jane and John here, and I listed their assets. So I guess, Williza, do you want to run down as well? I guess we will run down asset by asset and just sort of explain to everyone, you know, what happens to that specific asset in the case of one or both passing. So obviously starting at the top with the family home. So
Sure. So the family home is owned jointly. Now, with joint assets, they don't form part of your estate, so they can't be dealt with by will. So if John were to pass away, Jane would take ownership of the family home. So it's the survivor takes all principle.
And that's an automatic transfer. So I guess one of the things too, when we're talking about through your estate, when we say that phrase, through your estate, essentially what we're talking about is dealt with by the will. Because, you know, upon your passing, your estate is the assets that fall within the will. So, you know, just as a context piece. So for the CBA shares that are in Jane's name?
Because they're owned by Jane personally, they would form part of her estate and can be distributed as per her will.
Okay, so Jane passes away, the CBA shares form part of the estate. Whatever happens to be in the will document, in whatever that happens to look like, gets transferred as per the instructions. Yep. Okay. So
next off, we've got an investment property owned by John. Now, if John were to pass away, again, that would fall part of the estate.
Yep. So I guess in this scenario where, you know, the CBA shares, Jane owns them, John passes away, nothing happens, right? Because the shares are owned legally by Jane. So if she continues to exist, so she owns. Same with John, right? Jane passes away, John still exists, then, you know, he continues to hold the ownership of the investment property.
And now we've got John's super, and we're going to assume there is a binding nomination to Jane.
Yep. Okay. So I guess one of the key things here is superannuation is a tax structure. So it's a trust in its legal definition. So trusts act outside of the estate.
Mm-hmm.
So if whether there's a binding nomination or not, if John was to pass away in this scenario with $150,000, the assets that are held there aren't dealt with by the will; they're dealt with by the trustee.
Mm-hmm.
So, to say, for example, this is Australian Super,
Mm-hmm.
then if John was to pass leaving Jane would probably write a letter to Australian Super and say, I want you to transfer the money to me, please. And Australian Super, as the trustee of that superannuation fund or that trust structure, gets to decide. Now, let's say I'm John's estranged son from a previous marriage, and I obviously know that my father has passed away,
Mm-hmm.
and I want some money. There's nothing stopping me writing to Australian Super, assuming I knew it was there, basically saying I should have a cut, please,
Mm-hmm.
too. And the trustee, in its discretion, gets to decide. Yeah.
Even with a binding nomination?
Well, if there's no binding nomination. Yeah, that's a very good point, Williza.
Yeah.
So, again, I guess one of the things that we kind of would touch on is that there should be a binding nomination. Yeah.
So if John's long-lost stepson makes a claim against the estate,
Yep.
his superannuation would not form part of the estate. I think that's important.
Absolutely, yeah. And there's no ability for the long lost son to talk to Australian Super and say, yes, please, can I have some? Because there's a binding on the trustee,
Mm-hmm.
nomination for how that money gets paid out.
And if there was a binding nomination to the legal personal representative,
Yep.
John's long-lost stepson could make a claim because it would then form part of the estate.
Correct. So I guess the terminology on the binding nomination, legal personal representative, essentially means your estate. So the person who steps in. Now, typically, if John passes and he has a will, typically the Jane is going to be the executor. It may not always be the case, but I would say 95 times out of 100, that's going to be the case.
Mm-hmm. What about the family trust?
Yeah. So again, coming back as a trust in terms of tax definition,
Mm-hmm.
Nothing in there forms part of the estate. So interesting in terms of what happens with those monies. So for those clients out there that do have trusts, this is going to be particularly relevant to you. And it's probably one of the holes, I suppose, that we've been finding in a lot of client situations, in that we've got wills and powers of attorneys in place, but not necessarily instructions for what's happening with trust, and we'll move to self-managed super fund assets. So trusts in their inherent structure have a trustee. So how the trusteeship is structured, that has a big impact on how the money is dealt with when one of the trustees passes away. Because there's two scenarios here. One is having individuals as trustees, and
Mm-hmm.
one is having what we call a corporate trustee. So that's basically a company with the individuals as directors. So do you want to walk through, I guess, what the impact of those two scenarios are?
Sure. So if John was an individual director of the trustee,
Yep.
and he were to pass away,
Yep.
would there be provisions in the trustee, or should there be something in the trustee that should say what should happen?
Well, that's a good question. There's two questions there. Is there? Well, I guess that the trustee we'd have to refer to the trustee. Now, every trust is different, so Your trust deed might be completely different to my trust deed. That's a thing for the trustees of the trust to decide when and if the trustee is upgraded. But ideally, the second question, should there be? Ideally, yes. Or if it's not dealt with in the trust deed, it should be dealt with as terms of part of the will. So
yeah, and that's, I guess, different if you had a corporate trustee.
Yep.
It would just continue upon John's death.
Yeah, correct. So essentially, and this is why we, I guess, recommend corporate trustees to most clients for this reason, is that the corporation or the company that's the trustee company continues. So, effectively, if John was to pass, his directorship needs to change. So I think there should be something in the will or the company constitution that incorporates that if one of the directors passes, I suppose you would, and again, this is going to be specific to client circumstances, like if it's John and Jane, if John passes, Jane remains a director, she can, take over, she can be a sole director, that's not an issue. But if they both happen to pass, what happens to the directorship, right? So, because ultimately, that's who has the power, right? So you might have the best will and power of attorney and everything's set up, but you've got a trust and, you've got a few $1 million in your trust, but you haven't dealt with that adequately. Who gets appointed to the directorship of the company has a real impact on what happens with those assets.
Most definitely, yeah.
Absolutely. So, if you've got that structure, it's something, we really should be having the conversation about. Because the other thing too, coming back to, I don't want to get stuck in the weeds here, but in terms of individual versus corporate trustees, the issue also is the trustee owns the assets in terms of as a legally, what's the term for it? Like,
so it's split ownership.
Beneficially owned. That's the word I'm looking for here. For the beneficiaries.
Yeah.
Let's say it's Williza and I pass away. Then if you've got 40 shareholdings in a portfolio in there, you have to write to the registry for every single one of them and change the ownership, because the ownership is individually, I guess that we individually would, jointly would own them in trust for the beneficiaries, and it creates also a tax issue. So having a corporate trustee set up from a tax perspective and also from a what's the word I'm looking for, from an estate planning perspective, is absolutely by far and away the preferred outcome. Yes, it's more expensive, but in the situations where one or both trustees pass, it absolutely makes sense to have it set up that way.
Most definitely. Now, going on to the bank accounts.
Yeah, yep.
John's bank account, if he were to pass away, it would form part of the estate assets.
Yep.
And his will can distribute the asset as per his wishes. Same with Jane's bank account.
Yep.
And bank account number 3 is held jointly. Now, if John were to pass away, that would automatically just become Jane's bank account.
Yeah, correct. As it's a joint asset. Yep. So automatic transfer. We've probably missed one in there in the middle, the self-managed super fund. So similarly, I guess, to the superannuation conversation that we have, I guess the only difference here is that the trustees of a self-managed fund are the members. So ultimately, within that structure, the trustees have full discretion about what happens and power about what happens. So if you think about, I guess, the mechanisms of one or both of the, members passing away, the surviving partner or whoever's nominated in terms of their trusteeship is the one who ultimately decides, I guess, what happens with that money.
So if John were to pass away, Jane would get to decide.
Yeah, assuming that it's a John and Jane. But let's say it's John, Jane, and then the 2 kids who were members, and John and Jane both happen to pass. Well, then the 2 kids who are members of the fund, under the rules of self-managed super fund, they've got to be directors and members. they're the ones who ultimately get to decide what happens as trustees of the fund. So it's there's some complexity there that most people don't think about in the context of, because everyone thinks they're going to live forever unless you get past 60, I suppose, is when most people start thinking about this. But unfortunately, touch wood, not all of us get there. So I think the thing that we're trying to highlight through all of this is that there's some complexity in there, and the specific outcomes based on the circumstance set, depending on what happens, really needs to be tailored to your specific situation.
Moving on, just wanted to chat about powers of attorney. Now, it's a legal document that allows someone to act on your behalf, and they are pretty powerful.
Yeah, absolutely.
So if I were to appoint Chris as my power of attorney, he could do anything that I could legally do, or make decisions for me.
Yep, absolutely.
The only thing he wouldn't be able to do is make my will.
Yeah, it's pretty, just far-reaching, I suppose. And so again, some due thought from people in terms of, who's the person, I suppose.
Yeah, definitely.
And it, also something that you should probably think about on an ongoing basis. I don't know, in terms of the clients, I guess we see is like, you ask, do you have a will or powers of attorney? You'd be like, oh yeah, I did that 15 years ago. And I guess the, relationships aren't static. So, we see it not too often, but relationships do break down over time. So is the person you've appointed as your power of attorney still the person that you want to be making that decision based on life as it is today? So it's important that I guess that you're continually sort of checking in on who you've appointed. Because it might well be you have a marriage breakdown and your ex-wife is your power of attorney. So
if you're in a car accident, she gets to decide.
Yeah, absolutely. Yep. And legally, sorry. Not to scare everyone out there.
No. Just to briefly go through the different types, there's a limited power of attorney, which can be granted for a specific purpose, such as you want to sell a property.
Yep.
And you're overseas and you just need someone to act and sign papers on your behalf.
Yep.
There's a general power of attorney. Now, these lapse if you lose mental capacity.
Yep. So, you need to, I guess, that's pretty obvious. There's nothing really more to explain there.
And then we have enduring powers of attorney that continue beyond the time that you do lose capacity.
Yep. So I guess just running through the different types there, pretty straightforward. So this is an interesting one, this one.
Yeah.
It's something that's really coming up more and more often. And something that I've unfortunately seen over the last couple of years. And for those who aren't necessarily watching, I guess we're talking about elder abuse. So this is, and I think becoming, that's anecdotally in terms of what I have seen, becoming more, I guess, prevalent in the community.
Well, especially as the population ages.
Absolutely, and there's a vast intergenerational wealth transfer that's going to happen over the next couple of decades. I guess the baby boomers are all kind of hitting that point, right? And wealth's going to be transferred to kids potentially, or to elsewise. It's, I guess, just something that probably most of the community need to be sort of vigilant on aware about, because it's pretty ugly.
Definitely, and power of attorney is such an important thing that it can enable financial abuse to occur.
Absolutely, yeah. And I guess for those who have aging people in their lives, or those who are sort of reaching that period in their lives, will see the loss of confidence as it happens, the lack of clarity in decision making. It's hard, and it's really complex and full of ethical dilemmas, and I think it's just really important to highlight that if you see it, just to, I guess, raise it, ideally with the person that you feel like is potentially maybe getting abused, but also, with the powers that be, in however that looks. But yeah, it's definitely something that we are pretty vigilant on.
Mm-hmm.
So especially for older clients, in terms of like bringing in children into meetings, it's the first thing that I'm assessing.
Because essentially, if, for example, I had a stepmom, and I was her power of attorney,
Yep.
and she was losing capacity,
Yep.
I could just go into her bank and just
Absolutely.
take anything I wanted from her bank account.
Yep. Absolutely. Yep. You're within your rights to do that as a power of attorney.
And I guess that's why it's also a kind of hidden form of abuse.
Absolutely. Yeah. And also, it doesn't even necessarily have to be those who have power of attorney. Like, I guess entitled children is a huge one, and that's probably the biggest one that I've seen. Is parents are aging, they don't need as much money, and the kids are like, well, I'm going to get this anyway. You're on your way out. Can you just give it to me now?
It's just such an awful attitude.
It's horrible. Yeah, it's really horrible. But
it exists.
Absolutely. I've seen where kids have tried to force the mum, I shouldn't say that, force the parent force the parent to sell the asset so that they can pay down their mortgage.
Oh.
And it's like, it's pretty horrendous. So, I don't know. It's something, I guess people should be aware of, that we are aware of it, but also, take it into consideration when you're thinking about powers of attorney, when you're thinking about, your overall estate planning, and I guess just considerations as you start to get older. How do we try and limit the impact of it?
That comes to the end of our presentation.
Yeah, so pretty wide-ranging discussion, lots of complexity here. Just think for those of you who if this has hit a nerve, something that you want to discuss, something I guess that we've maybe talked about in the past but not necessarily action because at the time it wasn't something that was particularly important. Just reach out. You know where to find us. But obviously you can see a disclaimer up here. None of this is specific financial advice. None of this ever is. But have a read of that if you wish to. But thanks for joining us today, Williza. It's nice to formally introduce you to everyone.
Thank you.
So for those who ever get to speak to Williza or email Williza, you obviously now know who she is. Nice to chat. All right, thanks everyone. We'll see you next month.
Thank you.